For the second accused, it is Mr. Nyabuto. Third accused, Mr. Magoa. Makoha. For the fourth accused, it's Mr. Kisilu. Kisilu. Mr. Sindeu is for the fifth, sixth, seventh. Sindeu. Fifth.
A5?
Yes. A6, A7, and A8. Yes. Mr. Wandungi is on record for the 9 and 10 accused persons, and Mr. Kisilu is holding his brief. Mr. Kisilu.
That is, he said Mandugi is for?
Is for the 9th and 10th accused persons.
Okay.
Yes. Your Honor, I need to explain the absence of the first accused. The first accused was assigned some state duties which require his personal presence. And he has instructed me to seek permission of the court that the proceedings for today do proceed in his absence. Your Honor, Article 50, Subarticle 2, F of the Constitution grants an accused person.
Yes, slow down.
Yeah, sorry, Your Honor. Yes, grants the accused person the right to be present during his trial. The accused person can waive, and indeed has instructed me that his right to be present he has consciously taken the decision to waive it. And with the court's permission, the proceedings can go on in his absence, having waived the right to be present. The waiver is limited to today's proceedings. I respectfully urge Your Honor to allow the proceedings to go on in his absence. Thank you.
The state does not wish to oppose the application. We have looked at the provisions of Article 50F. And we have noted that the accused person has a right. He can elect not to be present during the proceedings. However, we note that the waiver is only in respect to these proceedings, and therefore we are not opposing that application.
So the application by council for A1 is hereby granted. Displayed.
We are most obliged.
That takes me to number 2.
Yes, Your Honor, like I had explained earlier, the second accused is on the way. It's only that his car had a minor mechanical problem on the way. But I've just spoken to him. He's coming at the time he called.
Can you show him a video of what is happening here? And determine whether we should wait for him or we also wait to decide. And at the same time, I think
Your Honor,
prosecution is philanthropic enough.
yes. Your Honor, I'll be requesting, first on behalf of my colleagues, I'll be requesting for the indulgence so that the court can proceed as my client makes his way to court. Because I've just spoken to him. He's keen on attending, but he can proceed as comes in. I therefore wish to make the application on his behalf that we do proceed as he makes his way in.
We give specific instructions that we can respond to. Are you saying he's also waiting?
Your Honor is waving.
Because we can't.
He's waving. He's waving.
We're talking about two things here. Proceed as wait. It's either he waves.
Your Honor is waving his right to be present. For this particular session.
We have no objection.
So application equally allowed. It's free. Most of
Yes, please, Your Honor. I am Mrs. Morondo, then Ms. Bella. The purpose of today's mention, Your Honor, was to enable the prosecution make an application to withdraw this matter. But before I argue the application, I wish to indicate the circumstances that led us to make that application. The accused persons in this case were charged with 6 counts of corruption and economic crimes offenses. They were charged with 6 counts of corruption and related economic crimes offenses on 26 July 2021.
It's counts of corruption related cases.
Yes. On 26 July 2021. Upon taking plea on 26 July 2021, The matter was fixed for the trial conference on 9th August 2021. The prosecution was unable to make full disclosure on the ground that we had not been given all the materials by the investigating officers to enable and serve the defense. Your Honor, the matter was fixed again on 27th August 2021, again for the trial conference to enable the state serve all the remaining documents. On 27th August 2021. Regrettably, Your Honor, we were not able to disclose the documents we were required to serve, as the same had not been supplied to the prosecution by DCI. And therefore, we could not comply. Your Honor, the matter was fixed for hearing on 5th September 2022. And Your Honor, when we appeared before this court, we informed the court that we have received several letters from accused number 5, 6, 7, and 8, requesting we received letters from 5th, 6th, 7, and 8 accused persons requesting the DPP to review the decision to charge in this matter. Your Honor, in light of the request to review, the prosecution team sat and reviewed the evidence. And at this stage, we realized that we were not able to respond to the letters without the evidence we had requested from DCI at the time we were charging. Your Honor, we called for a meeting.
Without the evidence that
We had earlier requested from DCI to enable us fully prepare for the hearing of this matter on 5th September 2022. Your Honor, we called for a meeting between the DCI team and the ODPP prosecution team so that we could go through the original file and the exhibits and identify the way forward. Your Honor, the DCI team did not respond to our request and nor avail the original file. And nor avail the original file and the exhibits required to enable us to study the file again. Your Honor, I wish to indicate the letters that we wrote to DCI requesting them to cover the further areas we identified. We wrote one on 28 July 2021. Yes.
how many letters?
We wrote 3 letters. The first one dated 28 July 2021.
Dated
28 July 2021.
second one.
The second one is dated 9 December 2021. 9th December 2021. And the third one is dated 23rd August 2022. Your Honor, there are others we had written but I have not carried today. But the point we are making, Your Honor, is that despite the several letters,
Yes.
the DCI did not respond. And therefore, we were not able to get the additional evidence that we had requested from the DCI. Your Honor, on 15th October 2022, the office was served with an affidavit from the office of the DCI. The same is sworn by the investigating officer, Kuria Obadia, and it is filed in this court on 2nd November 2022. It is filed in court on 2nd November 2022. The affidavit, Your Honor, is self-explanatory and is filed in court, but let me highlight paragraph 7. The investigating officer, Your Honor, in paragraph 7, admits that some crucial areas of investigations in this matter were not adequately covered as the investigating officer was not given sufficient time to investigate this matter and make recommendations.
Was not given sufficient time
To fully investigate this matter and make proper recommendations. he admitted that he was under pressure from his boss, the DCI, the then DCI, Mr. George Kenote, to complete investigations and make recommendations to charge the accused persons in this matter. The same areas that were not covered, Your Honor, the IO indicates that these areas could have shed light on the culpability of the accused persons or otherwise in this court.
The uncovered areas?
The uncovered areas would shed light in determining the culpability or not of all the accused persons in this case. Your Honor, the lead IO deposed at paragraph 8, at paragraph 8 of his affidavit, that it would be prejudicial to the prosecution case to proceed with the matter at this stage, noting that the outstanding areas of investigation have not been covered.
For the second accused, it is 6th July 2021. And the only accused person who stood on the dock on that day was the first accused, because he was the primary target. All these other 9 co-accused persons are no more than collateral damage. You will be bringing a sense of relief to them by permitting the withdrawal of this case before you. Thank you, Your Honor. I have nothing else to add.
retain pen captures for the others? Or?
Your Honor, on behalf of the second accused person, I want to confirm to court that the second accused person is now present in court for the court. Your Honor, the second accused person
That is Mr. Nyabuto.
Mr. Nyabuto. Your Honor, the second accused person is not opposed to the application by the DPP to withdraw the charges under section 87A of the CPC. Your Honor, the second accused person has always maintained innocence and his only connection to the charges before this honorable court is that of being a friend to the first accused person and secondly for being the then chairperson of Mathira CDF committee where the first accused was then a member of the National Assembly. Your Honor, the charges before this court are the epitome of the abuse of police powers and were meant to injure the political ambition of the second accused person to become the senator of Meru County.
So asking, as we move towards that direction, I was wondering, really, how can we do that?
Sorry, Your Honor?
How can we prove those issues? You start imputing reasons. They will say they are withdrawing because of A. Now you are adding others.
Your Honor,
We may not give them time to respond. I'm saying it's an easy application. Let's not make it very difficult.
very well, Your Honor. Your Honor,
It's like he covered everything.
Very well, Your Honor. We therefore,
So
on
can you
behalf
let
of
me not, who was supposed to become senator for? Like, I mean, it's who? Number?
accused number 2
Accused from becoming senator.
for Nyeri,
If he did stand, did anything but okay. You see the direction we are taking.
yes,
No one bad him. Did he even stand?
he is. The people of Nyeri were very clever to make their own decision.
So he is.
He is.
Okay. So you can see now how you are
Yes, and Your Honor,
mixing up things.
without,
And he is now.
yeah, without
You will say, in
post
fact,
charge.
that was not the reason. People had the right to make their own decisions.
Exactly that. Very well. We therefore do not oppose the application for withdrawal.
So let me add, but he is now, in fact, the I was telling my clerk, it's like this court is becoming a parliament. We have the how many? I didn't know. Now this is number 8.
Your Honor, it's because the charges were politically.
Those ones from becoming senator, but in fact. So you fully identify with Mr.
The submissions of our landed.
On behalf of the third accused, Your Honor, my name is Nakuru.
I hope you didn't take offense.
Very well, very well.
Your Honor, I'll be very brief. First of all, I do support the application to withdraw the trumped charges against the third accused. And add that, Your Honor, this is a serious indictment on both 2 officers of the DCI and the DPP. In the sense that, as much as we would want to put all the blame on Mr. Kinot, who unfortunately is not here to make his presentations, but the office of the ODPP is equally liable, if not more liable, culpable of this miscarriage of justice, in the sense that when we promulgated the Constitution, we anticipated the situation where the last say on whether to charge a person or not should fall on the DPP. So it's very sad. It's a very sad day in Kenya to have a police officer who an affidavit of this nature. Indeed, they are the driving seat. They are the ones who instigated these charges. The ultimate decision should have been made by the DPP, because the Honor of this line does not have power to prosecute. Having said that, Your Honor, I think it's about time, Your Honor. This is a very good opportunity, which I urge you to grab with all your 2 hands, and perhaps make some declaration or a decision that should be binding to these institutions, these criminal investigation institutions, that going forward, and perhaps before the DPP profers charges against any person, they should first have full disclosure of all the documents or evidence they wish to rely on. It's within your power, Your Honor. Because, Your Honor, what guarantee do we have that going forward, the new DCIO and the new DPP, if a new one will come, which should become actually, will not have this blame game again.
You're saying that there should always be full
Disclosure before an accused person is allowed to take a plea, Your Honor. It's just to secure. I heard your sentiments, Your Honor. You are very worried, and I was more worried. Can you imagine you on the other side and you are worried? You can imagine me on this other side. I was more worried.
We are generally aware people. When they hear your name and mine, where we come from, police, can't even sleep.
Yes, now to avoid that abuse.
So let me capture that. The court should make recommendations to the effect that there should always be full disclosure
before an accused person is allowed to take plea.
Before accused person.
Is a very necessary precautionary measure, so that we do not have a situation like this one in future, where one institution comes and says, no, we are not supplied with sufficient evidence before we prefer charges. Yet you are supposed to have had this evidence before you prefer charges. It's within your power, Your Honor. And Your Honor, in as much as people don't say it much,
Just hold. Preferred charges
yes, Your Honor.
pending supply of evidence.
Yes, yes, Your Honor. And Your Honor, I was making a point that in as much as we don't say it much, it's not only.
So,
yes.
Yeah, you said we can make law. How does this one find its way in the law books? How do we call this one? Then you name it after you. This kind of charges. This kind of charges. Then we attribute it to this court. Not to me. I'm saying you came up with a very nice description,
Yes.
so that an institution does not prefer charges on
Without the
basis
benefit of the evidence, proper evidence.
Can we call it an anticipatory charge?
No,
Okay, proceed.
Your Honor,
Without supply of evidence, I captured that very
Yes.
well.
I anticipate that Your Honor, you make a ruling after this, and in your ruling you can give direction on how these criminal institutions should be guided on how to make or prefer charges in the future for the protection of everyone. It doesn't matter who occupies the office or who becomes the president or the deputy president. So that Your Honor, that one will help in many ways. One, it will stop the abuse, like we have witnessed here, abuse of prosecutorial powers and abuse of investigation powers by the police. And then two, it will also ensure that there is speedy, expeditious disposal of disputes that should come before court. It's very clear. So as my request to you is that as you rest to write your ruling on this application to withdraw, perhaps you can give guideline that in future to avoid this abuse, this institution should first have full disclosure before preferring any charges against this institution. And speaking for my client, Your Honor, my client is a professional, just like me. He's a banker, Your Honor. So there is almost irredeemable reputational damage that she has undergone because of these charges. And not just her, even the institution she represents, Your Honor. It's like me being judged because I've represented a client, Your Honor. But Your Honor, these institutions must respect professionals. And as you retire to rest your ruling, perhaps you might also put that right, which is very clear. We must protect our professional bodies. For example, Your Honor, we cannot arrest these journalists for covering these proceedings because we don't want it to be covered. We cannot arrest them. We should respect all professions as they undertake their duties. And it's within this court, Your Honor, to give those directions. Lastly, Your Honor, in as much as it's not within the purview of this court, but I'm afraid because, Your Honor, we shall sue these institutions for malicious prosecution. So there is a danger that taxpayers will lose their money. So therefore, Your Honor, the request I made before, that there should be full disclosure first, will also help in alleviating such problems like this one. And Your Honor, because as I sit down, Your Honor, because the humiliation was so public, Your Honor, I think there should be, the apology should also be made public, just like as dramatic as the arrests were. Thank you, Your Honor.